Now, it doesn't help, of course, that because of these commonly known racial crime statistics, that the entire thing becomes hyper politicized. And of course, we have a corrupt media, right? So the corrupt media does things like this. It does things like this. It racializes all of this in an extremely biased manner. So the top news story involves the case of Ralph Yarl. Ralph Yarl was a young black man who approached a home, knocked on the door. He thought he was there to pick up his brother, but he was at the wrong address. The door opens up. Ralph Yarl begins to open up the screen door, and the homeowner inside the house shoots him. Doesn't kill him, but shoots him, is charged, criminally charged. Was about to go to trial just a couple weeks ago, I think, but took a plea bargain just before the trial started and then died like a week later. The shooter did. Very elderly man, not in good health. But when the media described that event, in which a white homeowner had shot Ralph Yarl, a black teenager, they were very explicit about all the racial components. A judge orders a white man to stand trial and face charges for shooting Ralph Yarl, a black teenager who rang his doorbell after coming to the wrong address. And of course, as the media does, white is in lowercase and black receives a capital B at the start. Don't really know why that is. Just another indication of bias, as far as I can tell. But in the case of this stabbing, where the stabber was black and the victim was white, there's no mention of race in the headline. Instead, this headline from the same news agency reads, a high school student was charged with murder after Frisco, Texas police said he fatally stabbed another student during a confrontation at a track meet Wednesday morning. Not a mention of race of either party. So for the media, apparently mentioning race, making something a racially energized case only matters when the person who used force was white and the victim of that force is black. And when the reverse is true, which is by far the more common scenario, then they don't want to talk about it. So when we see that kind of biased coverage, it doesn't help public perceptions of these events. It actually contributes to a more racially energized, racially perceived set of circumstances about the event. It's very unhelpful. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day Law of Self-Defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there. And today we're here to talk about a very unfortunate event, a killing at a track meet in Texas, Frisco, Texas, in which one student stabbed and killed the other student. And as you might imagine, we've gotten a lot of calls here at Law of Self-Defense for our take on all this. The first thing I'll say, and I am, of course, attorney Andrew Branca for the Law of Self-Defense, where our expertise is use of force law, self-defense, defense of others, defense of property, and so well suited to this particular topic. The first thing I'll say is we don't really have good answers because we don't really have good facts yet in this case. The correct legal answer to a reasonable degree of legal certainty is a function of applying the law to the facts, the law of self-defense. Now, we know the law, and we'll step through that here with all of you, but we only have the vaguest sense of the facts so far. So, if you've come here for a predetermined legal conclusion on this lethal event, we don't have that for you because we don't have the facts. And until we have the facts, credible facts to apply, it's difficult to know what the right legal answer is here. What's not difficult to know, however, is the right legal question. And that's what we'll really be covering here today. getting to the right legal question so we know how to apply the law to the facts appropriately. So, for those of you who may not be familiar with this breaking news, what we're dealing with here is just this past Wednesday, a few days ago, April 2nd, Karmelo Anthony stabbed Austin Metcalf in the chest, pierced his heart, resulting in his death. And if you've never seen this kind of heart injury um, inflicted by a knife, I've certainly seen plenty of crime scene photos. It had to have been a horrific experience. I mean, it's like a fountain of blood. When it happens inside a dwelling, the walls and ceilings are literally painted with blood. So that's what would have been experienced here. Of course, this resulted in Metcalf's death. He died in the arms of his twin brother, who was also present at this event. Anthony is black, Karmelo Anthony. Austin Metcalf, the victim here, is white. Both of them were 17-year-old high school students from different high schools participating in a track meet in Frisco, Texas at the time. Karmelo Anthony fled the scene immediately after the stabbing, threw his knife into nearby bleachers, but he was shortly arrested by police and charged with murder. And upon his arrest, he reportedly conceded that, yeah, I stabbed that kid, that dude, that 17-year-old. But he asked the police officers if the killing might qualify as lawful self-defense, which technically speaking is a possibility here, as we'll see. So that's the question we'll be tracking today. Certainly the stabbing of Metcalf does constitute an intentional murder, unquestionably, unless it can be legally justified as a killing in self-defense under Texas law. So what does Texas law require in order for a use of deadly force like this to be legally justified? What does Karmelo Anthony have to prove in order for a jury to even consider the possibility of self-defense? Because he's not guaranteed the right to argue self-defense. And are there facts in this case, or could there develop facts in this case from which a jury might reasonably acquit Karmelo Anthony on the grounds of lawful self-defense? That's what we are covering here today. Let's talk about the elephant in the room, because this is an issue that needs to be dealt with when we're doing this kind of legal analysis of a use of force event of specificity like we have here. And that is that America has a serious, systemic, institutionalized, horrific problem with black crime in our nation. A very small percent of our population commits the vast majority of violent crime. And that small percentage is the roughly 5 or 6% of the population that is young black men. This has been true during my entire legal practice. It was true when Barack Obama and Eric Holder ran the Department of Justice and was collecting these kinds of statistics. If anything, it's gotten worse in recent years. And this is a societal problem, and something needs to be done. And it's been going on like this for a very, very long time. Here's a graph. I'm going to mute the music because it has annoying music in the background. And I'll just talk as the graph is running. But it starts about 1999. It continues to the present day. And it shows the murder rate by race. Asian at the bottom, white a little bit above that. Native, I guess, is Native American in the middle. And you'll see the black murder rate is tenfold higher, sometimes more, in this graph. And that's sustained over a very, very long period of time. It ranges between 20%, 30%. Here, this figure, not 20%, 30%, but 20, 30 out of 100,000 committing murder within this black demographic. And so we're all aware of this. Everybody's aware of this. Nobody's more aware of this than black people. Really, they don't like to talk about it. Of course, anybody on the left doesn't like to talk about it. They like to change the subject to something else. Like, why is this happening? Is this nature or nurture? We need, I don't know, more education, whatever it is that they want to talk about. But none of that is helpful in the moment. And it's not just things like murder. And it's not just particular cities or regions. I mean, this is a graph from Chicago, robberies in place of murders. And it shows here the two bars here on the top, the black percentage of the population, roughly 30%, and the black rate of commission of robberies, 90%. And the reverse ratio is true for every other demographic in Chicago. So we're all aware of this stuff. We all aware it's a problem. And, trying to deal with root causes doesn't help in the crisis of the moment. When your house is aflame, you need the fire department to put out the fire. How the fire started is something that's determined at a later date. It's not the question you're asking when the flames are shooting out of the windows. So it doesn't really matter what the root causes of all this are when we're talking about a specific event of violence. But it must also be said that these generalized statistics are irrelevant to any particular event of violence because they're not describing everybody in the demographic. They're describing a generality of the demographic. Not every young Black man is a murderer or a robber. The vast majority are not. So we need to distinguish between this very real, generalized societal problem of a very high rate of violence among Black young men generally, but when we're dealing with a particular act and whether or not that might be murder or self-defense, as we are here, the general data don't apply. You have to evaluate the individual individually. Obviously, I'm aware of all these generalized crime statistics. They don't play a role in my legal analysis of this particular case. I approach this case like I approach every case with an open mind. I look to the law. I look to the facts. Now, the facts here are scarce, so we don't have much to work with, but at least, again, as I said at the beginning, we can ask the right questions, and the right questions are important. Now, it doesn't help, of course, that because of these commonly known racial crime statistics, that the entire thing becomes hyper-politicized. And of course, we have a corrupt media, right? So the corrupt media does things like this. It does things like this. It racializes all of this in an extremely biased manner. So the top news story involves the case of Ralph Yarl. Ralph Yarl was a young Black man who approached a home, knocked on the door. He thought he was there to pick up his brother, but he was at the wrong address. The door opens up. Ralph Yarl begins to open up the screen door, and the homeowner inside the house shoots him. Doesn't kill him, but shoots him, is charged, criminally charged. Was about to go to trial just a couple weeks ago, I think, but took a plea bargain just before the trial started and then died like a week later. The shooter did. Very elderly man, not in good health. But when the media described that event, in which a white homeowner had shot Ralph Yarl, a Black teenager, they were very explicit about all the racial components. A judge orders a white man to stand trial and face charges for shooting Ralph Yarl, a Black teenager who rang his doorbell after coming to the wrong address. And of course, as the media does, white is in lowercase and Black receives a capital B at the start. Don't really know why that is. Just another indication of bias, as far as I can tell. But in the case of this stabbing, where the stabber was Black and the victim was white, there's no mention of race in the headline. Instead, this headline from the same news agency reads, a high school student was charged with murder after Frisco, Texas police said he fatally stabbed another student during a confrontation at a track meet Wednesday morning. Not a mention of race of either party. So for the media, apparently mentioning race, making something a racially energized case only matters when the person who used force was white and the victim of that force is Black. And when the reverse is true, which is by far the more common scenario, then they don't want to talk about it. So when we see that kind of biased coverage, it doesn't help public perceptions of these events. It actually contributes to a more racially energized, racially perceived set of circumstances about the event. It's very unhelpful, very unhelpful. Now, I did do a poll before we started. Let me pull those up so we can share those. I'll do the Twitter one first. Here we go. So I just talk about the case, describe what we'll be covering, and ask, what do you think actually happened here? First choice, first option is only Black Lives Matter. 3% of you picked that. I don't know who these 2 or 3% of you who always pick that first answer. Someday, I suppose, we'll meet in person and you can explain yourselves. The killing was self-defense. Even a smaller percentage chose that, less than 3%. And Austin Metcalf was murdered, 94%, by far the more popular choice. And we have much the same results on our YouTube poll, if anything, even more extreme. Only Black Lives Matter, again, 2%. Metcalf was murdered, 98%. Nobody picked self-defense. Now, there is a hypothetical set of circumstances where this stabbing could have been self-defense. It's important for all of us to acknowledge that we were not there. I was not there. I didn't see what happened. You were not there. You didn't see what happened. You have no personal knowledge of the event. We've heard essentially testimony from the twin brother who described the circumstances. That's evidence, but people might argue the evidence is biased. And in fact, let me play a video of the brother sharing his perception of the events. Let me pull that up. So this is a large chunk of the evidence that we do have is this, and similar statements he's made elsewhere. This person on the right, of course, is the brother of Austin Metcalf, pictured upper left, the victim of this stabbing. And there's Marcella Anthony in the lower left of the photo. So let's go ahead and listen to what the twin brother has to say.
There was this kid, before I knew his name now, this kid was sitting under our tent at track. We asked him to move. He started getting aggressive and talking reckless. And my brother stepped in and said, "You need to move." And he's like, "Make me move." Austin grabbed his backpack. This kid, I tried to whip around as fast as I could, but I didn't see the stab. But then I look at my brother, and then I'm not going to talk about the rest. So just that's
all right. So I'm going to stop there because it's understandably emotional stuff after that. I want to stick with the facts that are shared about the confrontation here. So I'll just rewind it a little bit.
Aggressive and talked to our tent at track. We asked him to move. He started getting aggressive and talking reckless. And my brother stepped in and said, "You need to move." And he's like, "Make me move." Austin grabbed his backpack. This kid, I tried to whip around as fast as I could, but I didn't see.
Okay, so what are we hearing here? We're hearing that Marcella Anthony was sitting in this tent, not his school. I believe also a relevant factor here could be that it was raining out, so people were seeking to get into the tent. You know what that's like. It would have been crowded under there. Space would have been at a premium. Presumably, Marcella Anthony has his own tent from his own team. These two were from different high schools, different teams at this track meet. And Austin Metcalf asked him to move to make space for the people whose tent this was. And Marcella Anthony became confrontational, is what we're hearing described here. Make me move. Does that sound like an invitation to mutual combat? Does that sound like provocation? Maybe provocation with intent. We'll get to more of that in a moment on the part of Marcella Anthony. Then we're hearing that Austin Metcalf didn't touch Marcella Anthony, but touched his backpack to move his backpack out from under the tent, presumably, and that's when he got stabbed. Those are facts in evidence. You may contest how credible they are because they're coming from the victim's twin brother, but nevertheless, they are facts in evidence that we have to work with. Now, there is a lot of misinformation also being promulgated. Some of it is just pure nonsense. Let me share some of that. So we have to be very careful about what we hear on the media about this. You have to look for corroboration, authenticity, provenance. Where is this information coming from? Here's a post on X about this. Someone trying to spin supposed evidence that's favorable to the narrative of self-defense. I'll blow this up a little bit so we can see it better, but I'm not going to read all this text because it turns out to be utter nonsense. But it describes a very different scenario. It describes a scenario in which Austin Metcalf puts his hands on Karmelo Anthony, breaks his phone, becomes physical, is the physical violent aggressor in this confrontation. Well, that would certainly sound more like self-defense, wouldn't it? Not a lock, of course, because it's hard to see the deadly force here that would justify Marcella Anthony going to a knife. But we don't have to worry about the details of this because it turns out, supposedly, this was posted by the chief of police of the relevant police department, the Frisco Police Department. Except it wasn't. It's all nonsense. It was totally fabricated. The Frisco PD, the actual official account, posted they're aware of a post from a fake account on social media purporting to belong to Chief David Shilson. This post is not from an official source and may contain information that is false. I think we have to presume that the information is false. And of course, because the event is racially energized, because disparate races were involved, we have a lot of people on X posting more nonsense. More nonsense. They tried to jump him. The twin brothers tried to jump Marcella Anthony. I don't even know what that means. I guess they're trying to say they tried to beat up Marcella Anthony, and that was supposed to be a justification for Marcella Anthony going to deadly force. Folks, this is a crowded tent at a track meet, lots of people present. This isn't a dark alley at 2 o'clock in the morning. Nobody was going to allow two 17-year-olds to beat another 17-year-old to death. It's utterly ridiculous. But this is the kind of nonsense. So you get accounts like this. It was self-defense. No one should have died. But if you're hitting me because I wouldn't listen to you and I stab you and you die, oh well. Well, first of all, there's no evidence that anybody was hitting Marcella Anthony. And it's not the law that you can stab someone simply because they put their hands on you. More nonsense from the same account. They bullied him. They broke his phone. They called him racial slurs. Inevitably, we had to hear that one, right? As if the magic evil word, the N word, justifies killing someone. I've never seen that in any self-defense statute I've looked at, folks, and I've looked at pretty much all of them, at least in every American jurisdiction. I've definitely looked at all of them. So we have to watch out for that. Of course, there is other stuff going on. Naturally, there are parties who want to present Karmelo Anthony in as favorable a light as possible. This is an image of him going around social media. Nice, clean-cut young man, the kind of photos we've come to expect in these cases. But of course, there's another reality too. Here's a post that's going around, popular at the moment, and it purports to show Austin Metcalf here at the top and Karmelo Anthony at the bottom. And they're trying to say that because this bottom right photo had gone around, that's Karmelo Anthony on the left of the bottom right photo holding the AK-like weapon. I don't believe it's an actual AK. I think it's an airsoft gun. But obviously, it looks kind of gangsta, right? Not favorable. Certainly not like this image. Quite different. So someone posted this to say, hey, just because Marcella Anthony is holding what appears to be an AK and making funny hand gestures in that bottom right photo, don't use that to demonize him. Here's a photo of Austin Metcalf holding a gun too. Well, there's nothing wrong with anybody holding a gun, folks. I've been handling guns since I was 9 years old by myself. It's fine. But I would suggest these two pictures, top and bottom, are not the same. The top is people holding guns and they're on a hunt. They're shooting outdoors, a lawful purpose. The bottom right photo looks to me rather different. It communicates a different message to me, especially when Karmelo Anthony appears to be throwing gang signs. Are they well known for engaging in the lawful use of guns or for the unlawful use of guns? For violence and mayhem and murder? Not that I expect any of that would make it into a prosecution, but it's the kind of thing we've said before, this kind of attempt to bias perceptions of the events with photographs. We all remember, I guess I shouldn't say all, I'm of a certain age now, and this happened more than a decade ago, but the shooting of Trayvon Martin by George Zimmerman back around 2012 in Florida. This is the photo that was distributed by the millions in the news media of Trayvon Martin, 13 years old, pleasant looking. Supposedly, if you listen to Benjamin Crump and Al Sharpton, he was murdered by George Zimmerman for the crime of walking through his own neighborhood while carrying iced tea and candy. That was the narrative that was being put out against George Zimmerman by the media, always accompanied by this very pleasant picture. This is not the person who was killed by George Zimmerman. The person who was killed by George Zimmerman was a well-muscled 17-year-old high school student who actively engaged in street fighting. He had videos of himself street fighting on his phone, a slightly different demeanor than the Hollister t-shirt. And when the police arrived at the scene where Trayvon Martin had been shot by George Zimmerman, this is what George Zimmerman looked like. This is the result of the beating that Trayvon Martin had been delivering to George Zimmerman. By the way, the back of Zimmerman's head looks much like this. That nose is broken, by the way, because Trayvon Martin had punched George Zimmerman in the face hard enough to knock him on his back and then mounted him and was beating his head into a sidewalk. There's no question about this because we had eyewitness testimony of the ground and pound. That's how the witness described it. MMA ground and pound style beating, and we have the injuries. This was taken immediately when the officers arrived on the scene. Now, Here's another interesting tale for all of you. The prosecution tried to hide this photo. They didn't want to share it with the defense, as they were legally required to do. This is obviously evidence that's exculpatory, consistent with Zimmerman's claim of self-defense. He didn't just walk up and shoot Trayvon Martin. He was the victim of a life-threatening beating when he finally, desperately, pulled his 9mm Kel-Tec pistol and fired a single shot into Trayvon Martin. The prosecution tried to hide this photo, and when they were ultimately compelled to share this photo with the defense, you know what they did? They shared a black and white version of this photo, so you couldn't see the blood. That's the kind of gamesmanship that happens in these cases. So the basic facts we have to work with are what's described by the brother. Of course, other facts could develop. We'll have to wait and see. We'll have to evaluate their credibility, their provenance. But with the evidence we have, we can at least take a look at what the correct legal questions are, even if we don't fully have the evidence we need to arrive at a legal answer to a reasonable degree of legal certainty. And the questions are knowable because the questions are framed by the actual law of self-defense in Texas, which we turn to now. So, like many states, Texas, in effect, divides use of force, the legal justification for the use of force against another person, into two buckets. First, what's required for you to be justified in using just non-deadly force in self-defense? Your hands, pepper spray, force that is unlikely to cause death or serious bodily injury. And that law, the non-deadly defensive force law, is Texas Penal Code Section 9.31, entitled simply self-defense. Then they have a separate statute with the additional requirements needed to justify the use of deadly defensive force, and that is found in the next sequential Texas Penal Code, and that is Texas Penal Code 9.32, deadly force in defense of persons. But you'll notice the first condition that you have to satisfy to be justified in the use of deadly force in defense of persons under Section 9.32 is you first have to satisfy the conditions for using any force in self-defense under 9.31, the non-deadly force statute. So we're going to start there. Let me go back to 9.31. Here we go. And I'll pull this up. Now, these are not the complete statutes. They're longer than this, but these are the relevant portions of the statutes for the case that we're considering here. Okay, so Texas Penal Code 9.31, when can you use merely non-deadly force in self-defense? So a person is justified in using force against another when and to the degree they reasonably believe the force is immediately necessary to protect against the other's use of unlawful force. Now, if you've heard me talk about this stuff before, you'll recognize in this what I refer to as the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. These are the building blocks of any claim of self-defense in any state. There are not 500 elements of a self-defense claim. There's not 50 elements. There's only 5, and only up to 5. Not all 5 are always required. They're not all required here. But if we think about those elements, innocence means you were the innocent victim of unlawful force. Imminence means that it's necessary for you to defend yourself in the moment, right now. Proportionality has to do with how much force you can use, only non-deadly, or can you use deadly defensive force? Avoidance has to do with whether or not there's a legal duty to retreat. And reasonableness means you had to have perceived and made your decisions in a reasonable way, not out of bare fear, not speculative, not imaginative. You applied your powers of reason to the facts before you. We see all that here, right? You're defending yourself against an unlawful force. That's the element of innocence, that you're the victim of an unlawful use of force, not, for example, a lawful arrest, which often involves a lawful use of force. That the attack you're defending against is occurring right now. The element of imminence, well, you have to be defending yourself using defensive force when it's immediately necessary. That's the element of imminence. The element of proportionality is built into this statutory framework, right? One statute for non-deadly force, a second statute for deadly force. That's the element of proportionality. The element of avoidance is not relevant here because Texas is a stand your ground state. It does not have a generalized legal duty to retreat before you can use force in self-defense. That's what the element of avoidance requires. Not only is Texas a stand your ground state, they're what I refer to as a hard stand your ground state. The jury is not even allowed to consider the possibility of retreat in evaluating whether your use of defensive force was reasonable. So we don't have that fourth element of avoidance here. We're really only dealing then with four elements of self-defense: innocence, imminence, proportionality. We skip avoidance. And reasonableness is stated here explicitly. The defender has to reasonably believe the force is immediately necessary. It's a very nice encapsulation of the elements of self-defense in this very first paragraph. Then they have a bunch of exclusions. Even if you meet these conditions, you may still not be legally justified in using force in self-defense. For example, the use of force is not justified, even if you meet those conditions, in response to verbal provocation alone. Well, what do we have here, given the description by the twin brother? That Austin Metcalf asked Karmelo Anthony to move out from under the tent, that they had a verbal exchange, that Austin Metcalf moved Karmelo Anthony's backpack out from under the tent. That's not physical force upon or threatening Karmelo Anthony. Everything else is verbal. So far, there's zero evidence that Austin Metcalf threatened to use or did use any physical force against Marcelo Anthony. The use of force against another is not justified if the defender consented to the exact use of force attempted by the other. What else did we hear from the twin brother? That effectively, Marcelo Anthony challenged Austin Metcalf to do something when he refused to move out from under the tent. Well, that sounds a lot like mutual combat. Make me, or provocation. I dare you. Go ahead. If it's mutual combat, if Marcelo Anthony is extending an invitation to Austin Metcalf to engage in physical violence to settle their differences, well, mutual combat is a mutual consent to the use of force. It's a traditional fistfight. You're each agreeing, consenting to the other's use of a fist against you because you're planning to use a fist against them. That's what a traditional fistfight is. That's what mutual combat is. And if that's what you're engaged in, if that's what was being offered here by Marcelo Anthony, he has no claim of self-defense, not even for the use of non-deadly force, much less a knife to the chest. Another exclusion, if the defender provoked the other's use or attempted use of unlawful force. So even if there's evidence that Austin Metcalf put hands on Marcelo Anthony, if that was the result of provocation by Marcelo Anthony, then Marcelo Anthony cannot claim self-defense here because he provoked the encounter. He can't claim self-defense for having provoked the encounter unless he does something particular. It says here, unless he had abandoned the encounter and attempted to retreat from the encounter. And then Austin Metcalf had pursued Marcelo Anthony. Then Marcelo Anthony would have reacquired a privilege of self-defense, but none of that happened here. Now, there is another issue I want to talk about here. I don't think it applies, but Texas has a rather unique exception to self-defense, and that's if you arm yourself to go to a confrontation to settle your differences with someone. So there's been some prior dispute between two parties. One of them arms himself and says, all right, now I'm going to go, face to face with this guy and settle our differences. But he brought a weapon with him. Now you can be carrying a weapon legally, and that's fine. But there are illegal ways to carry weapons in Texas. For example, concealed carrying a firearm without the necessary permit, at least when this statute was drafted. That would have been, Texas might have gone constitutional carry now. But the point is, if you're carrying the weapon illegally and you go to this confrontation, you seek an explanation from the other party, a confrontation while you're illegally armed, that loses you self-defense under Texas law. That loses you even the privilege to use non-deadly force in self-defense, much less deadly force. Now, most of the ways of unlawfully carrying a weapon in Texas law have to do with firearms. And of course, no firearm was used here. But Texas does have a weird provision for particular kinds of knives, carrying knives of a certain blade length, anything over 5.5 inches. It's a location-restricted knife under Texas law. And if you're carrying that, it's unlawful. It's unlawful possession of a weapon under certain circumstances. That would apply here on school grounds. So if it turns out that this knife that was used by Karmelo Anthony to stab Austin Metcalf had a blade in excess of 5.5 inches, that could be an issue, because that would trigger this provision. Now, the knife itself is not enough. You'd also have to argue that there would have to be evidence that Karmelo Anthony sought out an explanation from Austin Metcalf. Now that may develop, because I have seen reporting, which I expect is fake, but it could be true, that there had been prior confrontation between these two people. The people who are communicating those claims are trying to do it to make Austin Metcalf look bad, like he had bad blood out for Karmelo Anthony. But it would actually work against Karmelo Anthony, because it could be the basis for concluding that Karmelo Anthony went to this tent where he knew Austin Metcalf would be, in an effort to seek out an explanation for their prior conflict, and then used a location-restricted knife in the stabbing of Austin Metcalf, which would preclude the claim of self-defense, even for mere non-deadly force. Then we get to this paragraph here that makes clear that even if you meet all the conditions of Section 9.31, which is non-deadly force in self-defense, it doesn't justify you in using deadly force in self-defense. The use of deadly force, I lost my little pen here. Try this again. The use of deadly force is not justified except as provided for our purposes here in the next statute, 9.32, which we'll look at in just a moment. We also have a stand your ground language. If you're at a location where you have a right to be and you did not provoke the conflict and you're not engaged in criminal activity, you are not required to retreat. So that's Texas stand your ground law. And then it becomes not just stand your ground, but hard stand your ground, because under Texas law, the finder of fact may not even consider the possibility of retreat in evaluating the reasonableness of the act of self-defense, which means the prosecutor cannot argue to the possibility of safe retreat. All right, so that's 9.31. The conditions that have to be met before even mere non-deadly force can be used in self-defense. But for deadly force to be used in self-defense, as was done here, we have to satisfy different conditions. We have to satisfy 9.32, the next sequential statute, deadly force in self-defense. So let's take a look at this. This is what has to be satisfied for this stabbing to be lawful self-defense, the killing of Austin Metcalf by Karmelo Anthony. The first thing, of course, as we've already noted, is before you can be justified in using deadly force under 9.32, you have to meet all the conditions for 9.31. All the conditions for mere non-deadly force in self-defense. In addition to all of those, now there are additional requirements that have to be satisfied before deadly force can be used in self-defense. You have to believe that deadly force is immediately necessary. This goes to imminence, to protect the defender against the other's unlawful use of deadly force. So you need to be facing a deadly force threat before you're privileged to use deadly force in self-defense. That's the element of proportionality. If you're only facing a non-deadly force threat, you can only use non-deadly defensive force. You can't use deadly defensive force until you're facing a deadly force threat. Is there any evidence here, that Marcelo Anthony was facing a deadly force threat at the hands of Austin Metcalf? There's not much. Austin Metcalf was unarmed. Both of these were healthy young men. Now, the only argument I could see to a claim of Austin Metcalf presenting a deadly force threat, a threat reasonably likely to cause death or serious bodily injury to Karmelo Anthony, is that Austin Metcalf was there with his twin brother. So there is a potential argument here for a disparity of numbers claim, that a 2-on-1 attack would be very difficult to defend against. It might be readily capable of inflicting death or serious bodily injury on Karmelo Anthony. The problem is that's a much more credible argument if Austin Metcalf and his twin brother were attempting to beat down Karmelo Anthony in an alley at 2 a.m. with nobody else around. That's not what's happening here. Those are not the circumstances. This is a track meet. There's hundreds of people there. There's probably dozens of people in and around this tent. Nobody is going to just stand by and watch Austin Metcalf and his twin brother beat to death or maim Karmelo Anthony. That's not a reasonable assessment of the risk, even if you believe that the twin brother was going to cooperate with Austin Metcalf to inflict this kind of deadly force beating. And there's no evidence that Austin Metcalf had any intent to do anything of the sort. There's literally zero evidence that he made any conduct that a reasonable person could perceive as threatening in any manner, not even non-deadly force threatening, much less deadly force threatening. But if I were the defense lawyer for Marcelo Anthony and I were looking to find some argument of a perceived deadly force threat at the hands of Austin Metcalf, that's the only thing I could possibly see. And it's not very strong. I would not want to be the lawyer making that argument. I can tell you that much. So you need to be defending yourself against a deadly force attack before you can use deadly defensive force or be facing one of these enumerated violent felonies, none of which are relevant here: kidnapping, murder, sexual assault. Nobody is claiming that Austin Metcalf could be reasonably perceived as threatening any of these things against Karmelo Anthony. There's more stand your ground language here. If you're present at a location where you have a right to be, you did not provoke, you were not engaged in criminal activity, you are not required to retreat, and a finder of fact is not allowed to even consider the possibility of retreat. So these two statutes in combination set out the proper legal questions. And again, they really come down to the 5 elements of self-defense, with avoidance off the table, the 4 remaining elements of self-defense: innocence, imminence, proportionality, and reasonableness. To have a viable claim of self-defense, Karmelo Anthony would need to be able to argue that he was the innocent victim of an unlawful, imminent, deadly force, reasonably perceived attack at the hands of Austin Metcalf. And I just don't see any evidence to support that. None. Now, could such evidence develop? Might we get a cell phone video of Austin Metcalf somehow threatening deadly force harm to Karmelo Anthony? Sure, I guess that could happen. And if we get different facts, then obviously the legal conclusion changes. But I don't see any facts like that here. None. So it does not look good for Karmelo Anthony, to say the very least. Now, to be clear, Karmelo Anthony does not have to prove self-defense. Any prosecutor here would have to disprove Karmelo Anthony's claim of self-defense beyond a reasonable doubt. That's the burden of, we refer to it as the burden of proof. It's really the burden of persuasion. Who has the burden to persuade the jury of the truth or lack of truth of a claim in court? The claim here is self-defense. It's the burden of persuasion on the prosecution to convince the jury that they have disproven that claim of self-defense beyond any reasonable doubt, which happens all the time. It sounds like it would be hard to disprove, it sounds like proving a negative, right? You have to disprove self-defense. Trust me, it's not hard if you have the evidence to do it. But before we even get to that, before Karmelo Anthony can even argue self-defense in front of the jury, there's another burden of proof that has to be met, a prior burden of proof. It's called the burden of production. We saw that there are elements to a claim of self-defense. When you make a claim of self-defense, the jury is supposed to consider the evidence in support of those elements. But what if one or more of those elements has no evidence? There's literally zero evidence to support one of the required elements of a claim of self-defense, like a deadly force threat here, for example, by Austin Metcalf. Well, if there's zero evidence on an element, the only role of the jury is to consider evidence, right? To evaluate evidence. If there's literally zero evidence on an element, there's nothing for the jury to consider. And if there's nothing for the jury to consider, that element, from a technical legal analysis perspective, that element cannot be satisfied. And if it's a required element of the legal justification of self-defense, and it cannot be satisfied because of the complete absence of evidence on that element, there is no self-defense. If you're missing a required element of self-defense, self-defense doesn't exist at all. It doesn't just get diminished. It goes away entirely. And that's called the burden of production. And the burden of production is on the defendant claiming self-defense. So Karmelo Anthony has to be able to make an initial showing of more than 0% evidence on each of those 4 required elements of self-defense: innocence, imminence, proportionality, and reasonableness, before he's even allowed to raise the legal defense of self-defense in the courtroom. That's the burden of production. That falls on the defendant. If he cannot satisfy that burden of production, the prosecution will ask the court to deny him the privilege to argue self-defense at court. You don't have a magical ability to argue self-defense at trial. You have to qualify to argue self-defense at trial by showing there's more than zero evidence on each of the required elements of self-defense. So that's a burden of production that's going to be on Karmelo Anthony. And it's not uncommon, especially on these sketchier claims of self-defense, that there is no independent evidence for one or more elements of self-defense. And the defender is looking at an inability to argue self-defense in front of the jury unless the defender is willing to take the witness stand. Now, the burden of production doesn't require a lot of evidence on each of the required elements. It requires more than zero evidence. If there's even 1% of evidence to support an element of self-defense, then there's something for the jury to consider. And then the question becomes within the province of the jury to answer as the finder of fact. There has to be more than zero, but 1% would be enough to meet the burden of production requirement. And you can satisfy that greater than 1% by your own testimony. So Karmelo Anthony could take the witness stand and just say the words, I had a reasonable perception of an imminent, unlawful, deadly force threat at the hands of Austin Metcalf. That would satisfy his burden of production on the question of self-defense, and the jury would be given a self-defense jury instruction. Now, is that alone enough, that self-serving statement, enough to convince the jury that there's not even a reasonable doubt that it was self-defense? I would think not, but at least then the jury would get the jury instruction. And generally, jury instructions are given out pretty liberally. I would not expect Marcelo Anthony to end up without a self-defense jury instruction. I would expect him to get it, but I just don't see the evidence here to support it. I don't see any evidence that Austin Metcalf satisfies any of the elements of self-defense. That first of all, he was an unlawful aggressor towards the person of Anthony Metcalf. That's the element of innocence. The element of imminence, well, you can't have an imminent threat if there's no threat to begin with. I see absolutely no evidence that Austin Metcalf was presenting as a deadly force threat, which is what would be required for the use of the knife here by Karmelo Anthony to be legally justified. And I don't see how anybody could believe that Karmelo Anthony, was reasonably perceiving an unlawful, imminent, deadly force threat from Austin Metcalf. So based on the evidence we have before us today, again, changes in evidence lead to changes in legal analysis and changes in legal outcome. The answer changes if the facts change, obviously. But based on the evidence we have today, I don't see any viable path to an acquittal on the grounds of self-defense for this fatal stabbing of Austin Metcalf by Karmelo Anthony. But we are in the early days, right? We don't know what cell phone video might emerge. We don't know. There would have been many witnesses there to this event. We don't know what they're going to testify. I haven't heard from them. It would appear that most of the witnesses are going to be people who belonged in the tent, who were part of the group of Austin Metcalf, and not of the unwanted guest, Karmelo Anthony. But there we are. Now, having said all that, of course, in a courtroom, anything can happen. The most innocent person can be convicted. The most guilty person can be acquitted. And of course, we intentionally bias the system in favor of acquitting the guilty. That's why we require proof of guilt beyond a reasonable doubt. And if they raise the justification of self-defense, we put the burden on the prosecution to disprove self-defense beyond a reasonable doubt. And that's where I see things today in this case.